Rule 132, Presentation of Evidence. A. Examination of witnesses. Section 1. Examination to be done in open court. The examination of witnesses presented in a trial or hearing shall be done in open court and under oath or affirmation, unless the witness is incapacitated to speak or the question calls for a different mode of answer. The answers of the witness shall be given orally. Section 2. Proceedings to be recorded. The entire proceedings of a trial or hearing, including the questions propounded to a witness and his or her answers thereto, and the statements made by the judge or any of the parties, counsel, or witnesses with reference to the case, shall be recorded by means of shorthand or stenotype or by other means of recording found suitable by the court. A transcript of the record of the proceedings made by the official stenographer, stenotypist, or recorder and certified as correct by him or her shall be deemed prima facie a correct statement of such proceeding. Section 3. Rights and obligation of a witness. A witness must answer questions, although his or her answer may tend to establish a claim against him or her. However, it is the right of a witness, 1. To be protected from irrelevant, improper, or insulting questions, and from harsh or insulting demeanor. 2. Not to be detained longer than the interest of justice requires. 3. Not to be examined except only as to matters pertinent to the issue. 4. Not to give an answer which will tend to subject him or her to a penalty of an offense unless otherwise provided by law. Or 5. Not to give an answer which will tend to degrade his or her reputation unless it be to the very fact at issue or to a fact from which the fact in issue would be presumed. But a witness must answer to the fact of his or her previous final conviction for an offense. Section 4. Order in the examination of an individual witness. The order in which an individual witness may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. D. Cross-examination by the opponent. Section 5. Direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Section 6. Cross-examination. Its purpose and extent. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter, which with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias, or the reverse, and to elicit all important facts bearing upon the issue. Section 7. Redirect examination. Its purpose and extent. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. On redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court in its discretion. Section 8. Cross-examination. Upon the conclusion of the redirect examination, the adverse party may cross-examine the witness on matters stated in his or her redirect examination, and also on such other matters as may be allowed by the court in its discretion. Section 9. Recalling witness. After the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest of justice may require. Section 10. Leading and misleading questions. A question which suggests to the witness the answer which the examining party desired is a leading question. It is not allowed except A. On cross-examination, B. On preliminary matters, C. When there is difficulty in getting direct or intelligible answers from a witness who is ignorant, or a child of tender years, or is of feeble mind, or a deaf mute. D. Of an unwilling or hostile witness, or E. Of a witness who is an adverse party or an officer, director or managing agent of a public or private corporation, or of a partnership or associations which it which is an adverse party. A misleading question is one which assumes as a true a fact not yet testified to by the witness, or contrary to that which he or she has previously stated. It is not allowed. Section 11. Impeachment of adverse party's witness. A witness may be impeached by the party against whom he or she was called, by contradictory evidence, by evidence that his or her general reputation for truth, honesty, or integrity is bad, or by evidence that he or she has made at other times statements inconsistent with his or her present testimony, but not by evidence of particular wrongful act, except that it may be shown by the examination of the witness or the record of the judgment that he or she has been convicted of an offense. Section 12. Impeachment by evidence of conviction of crime. For the purpose of impeaching a witness, evidence that he or she has been convicted by final judgment of a crime shall be admitted if A. The crime was punishable by a penalty in excess of 1 year. B. The crime involved moral turpitude regardless of the penalty. However, evidence of a conviction is not admissible if the conviction has been the subject of an amnesty or annulment of conviction. Section 13. Party may not impeach his or her own witness, except with respect to witnesses referred to in paragraph D and E of Section 10 of this rule. The party presenting the witness is not allowed to impeach his or her credibility. A witness may be considered as unwilling or hostile only if so declared by the court upon adequate showing of his or her adverse interest, unjustified reluctance to testify, or his or her having misled the party into calling him or her to the witness stand. The unwilling or hostile witness so declared, or the witness who is an adverse party, may be impeached by the party presenting him or her in all respect as if he or she had been called by the adverse party, except by evidence of his or her bad character. He or she may be also impeached and cross-examined by the adverse party, but such cross-examination must only be on the subject matter of his or her examination in chief. Section 14. How witness impeach by evidence of inconsistent statements. Before a witness can be impeached by evidence that he or she has made at other times statement inconsistent with his or her present testimony. The statement must be related to him or her, with the circumstances of the times and places and the persons present, and he or she must be asked whether he or she made such a statement, and if so, allowed to explain them. If the statements be in writing, they must be shown to the witness before any question is put to him or her concerning them. Section 15. Exclusion and separation of witnesses. The court, motu proprio or upon motion, shall order witnesses excluded so that they cannot hear the testimony of other witness. This rule does not authorize exclusion of a party who is a natural person, b, a duly designated representative of a judicial entity which is a party to the case, c, a person whose presence is essential to the presentation of the party's cause, or d, the person authorized by statute to be present. The court may also cause witnesses to be kept separate and to be prevented from conversing with one another, directly or through intermediaries, until all shall have been examined. Section 16. When witness may refer to memorandum. A witness may be allowed to refresh his or her memory respecting a fact by any written or recorded by himself or herself, or under his or her direction, at the time when the fact occurred, or immediately thereafter, or at any other time when the fact was fresh in his or her memory, or he or she knew that the same was correctly written or recorded. But in such case, the writing or record must be produced and may be inspected by the adverse party who may, he who may, if he or she chooses, cross-examine the witness upon it and may read it in evidence. A witness may also testify from a such writing or record, though he or she retains no recollection of the particular facts, if he or she is able to swear that the writing or record correctly stated the transaction when made. But such evidence must be received with caution. Section 17. When part of transaction, writing, or record given in evidence, the remainder admissible. When part of an act, declaration, conversation, writing, or record is given in evidence by one party, the whole or the same subject may be inquired into by the other, and when a detached act, declaration, conversation, writing, or record is given in evidence, or any other act, declaration, conversation, writing, or record necessary to its understanding may also be given in evidence. Section 18. Right to inspect writing shown to witness. Whenever a writing is shown to a witness, it may be inspected by the adverse party.